Here with more on what is at stake today, potentially, is constitutional attorney Andrew Lieb. Andrew, thanks for coming on once again. Always good to see you. You called these social media cases some of the most interesting and impactful ones being considered by the High Court. We know that the biggest spotlight will be on this immunity case and former President Trump and what bearing that has on his legal issues with that case in D.C. But we'll get to that in just a second. What is your take on the social media cases and how the ruling could impact everyday folks?
Are you ready? It feels like Super Bowl Sunday for me. I've been having my espresso since about 6 a.m. This social media case is fascinating, and I'll tell you why. There's a case by Republicans, and then there's another case by Democrats, and they're both challenging what rights social media companies have to do things. From the Republican perspective, the president was influencing about getting rid of all these conspiracy theories about COVID. Can the president influence and change and motivate social media companies to do things? Now, from the Democratic perspective, there's these Republican laws that say, hey, there needs to be restrictions on the editor, the content moderator. Imagine the government could pass a law on Scripps News and say what editorial content we could do and say, hey, here's the disclaimer we have to have. Should the government be in our social media? We all say First Amendment rights, but doesn't the social media company have the First Amendment rights to do what they want, and the free market has the choice whether to be there? Do we want the government manipulating our thoughts? That's before the Supreme Court. I think that's huge.
Andrew, let's move to the case that Rob was mentioning earlier, and that is the presidential immunity one. This is the big case before the Supreme Court right now. The justices are tasked with deciding of whether he should be shielded from federal prosecution. Just remind our viewers what a ruling in favor of Donald Trump could mean for the two federal criminal cases against him, including, most significantly, the January 6th case.
Simple answer for a simple question. I have to tell you, they're gone. There's no more cases. He's saying that there's no way that he could be prosecuted. He's saying complete. He's made it clear all the time. He likes to emphasize the word complete federal immunity. He should have complete immunity. Interestingly enough, Judge Cannon down in Florida is holding a hearing today if that case should go forward on other grounds, and we'll see what happens there. But I want you to pay attention not to complete presidential immunity, but there's another key term, official acts. Are they going to just say maybe you can have immunity for certain acts and not others? Because what are these official acts? Is it official act to take, I don't know, let's say, government documents and bring them to your house, your club? Is it official act to try and overturn an election? I'm not telling you that they did that or not, but that's going to be something I expect to be punted to the lower courts to say, was he engaging in official acts? So you can probably bet that you're going to see a hedge here, not a complete presidential immunity or none whatsoever, but something in the middle. But this one's going to change the course of both the Florida case and the D.C. case with respect to prosecuting Donald Trump for all those felonies on federal crimes.
And that fascinating moment that's just hard to forget in this case is when his lawyer argued. They said, well, what if the president, ordered an assassination of a political opponent? Would he be immune to that? And Trump's lawyer was like, yeah, because Congress would have to impeach him first, and then basically the president could hire a hitman to kill his opponent and be okay legally if Congress didn't do anything. And I think that was a moment in court where everyone was like, whoa, what are you saying here? There's a lot of implications to essentially saying these kinds of crimes are okay for the President of the United States to commit, or creating some kind of test. Either way, it could delay the Jack Smith D.C. case, and that's maybe the bottom line. But it's a huge moment. Let's end with this note here. Last week, another major ruling of the Supreme Court that kept the abortion pill, mifepristone, on the market, a victory for abortion rights advocates in this country, the most commonly form of abortion in this country. At stake now is whether doctors can perform abortions in the case of a medical emergency, another critical, deeply personal issue. What are the stakes here? What are the arguments?
So the real question here is that we have about 22 states led by Idaho that have these complete bans on abortion. There's no exceptions, by the way, in the Idaho law about the life of the mother, the emergency. And we have this law since 1986 in the United States, a federal law that says if you take Medicare dollars hospital, you always, and I want you to key in on these words, need to stabilize emergency room patients, whether they got money, whether they got no money. If you go to the hospital, don't you and I, we have an expectation, show up at the hospital, they'll save you. Well, the question here is, does that preempt, does that overtake, does that stop the Idaho law that says, hey, it's criminal to go do that? You can't stabilize a pregnant mother if it's going to impact the pregnancy. And so the question here is, even these laws, these 22 states that don't have exceptions for the life of the mother, do federal funded hospitals, anyone who takes Medicare dollars, all the hospitals across the United States, do they nonetheless have to help the life of the mother at the expense of the unborn? Because according to this law from 1986, this federal law, and I think it's a good one, that no matter where you go, if you go to the hospital, you know, money, no money, the hospital will always do necessary stabilizing treatment. And I like to live in a society, forgetting abortion for a second, that I could trust the hospital that will always do their best to keep me alive. I like living. I don't know about you.
And yes or no, real quick, does the Supreme Court, once this case gets there, let Louisiana put the 10 Commandments, require the 10 Commandments in all public classrooms? Yes or no, then we got to go.
I'm going with no on that one, but maybe that's the 11th commandment.
Constitutional lawyer Andrew Lieb, appreciate your expertise, sir. Thank you so much. We'll be right back.